Should a seller allow a buyer to move into a home prior to closing? That's our topic for today, and we're starting now. Hi, I'm Lisa Salt with Vernon Salt Fowler, and we're often asked to address the question of a buyer asking a seller for permission to move in early. Or they might be asking to store furniture in the garage or something like that prior to closing. So the question is, should the seller allow this to happen? And we're going to talk about that today, but before we get to that, don't forget to subscribe to our YouTube channel. We're posting new videos like this and about the Okanagan every single week. So the short answer to a seller asking this question is, first of all, get independent legal advice. Now, what are some of the concerns you'd want to discuss with the lawyer? Number one, the sale might fall through due to a problem with the lender not advancing financing for some reason. And should this happen, the seller and the realtor are going to be back to square one trying to sell the house again. This time, though, with someone occupying the property as a renter. In a perfect world, the buyer would just vacate and move out and no harm done. However, there have been instances where the buyer won't vacate the property, and then the sellers are stuck taking legal action to remove the buyer. So this can cause a delay getting the property back on the market in a timely fashion. It's a huge pain in the butt also. Number two, the buyer might feel the house is already theirs and start making changes. Maybe changes that the seller does not appreciate, or maybe something that could devalue the property. And then if the transaction doesn't close, the seller's stuck with all the buyer's improvements, the purple walls or the half ripped up flooring and all the stuff that's only partially done. So that then impacts the remarketing of the property. Number three, what if the buyer sees something they didn't like, some defect that didn't come out in the home inspection? Now they want out of the deal. Or they might want to hold back. You know what, I'm not buying this house unless there's $5,000 for a new furnace or something. That's also a pain because then you're kind of held up ransom. Number four, worst case scenario is the sale doesn't complete at all and the buyers trash the house or put in an illegal grow up. Number five, what about insurance? Who's responsible if the buyers have a party and one of the guests falls and gets badly hurt? Or if some of the buyer's possessions are stolen from the house? Or what if the house burns down? The seller could suffer significant financial loss from the events. Or the transaction might be totally frustrated because the house they were going to buy isn't there anymore because it burnt down. If you ask a lawyer whether they would suggest allowing early possession before closing, a lawyer will typically advise against it. Now, if the seller insists and it's a good deal for everybody, then the lawyer will generally recommend that the parties enter what's called a buyer early possession agreement. That agreement sets out the duties and responsibilities of both parties. So examples of some of the issues typically addressed in a buyer early possession agreement. One, what happens if the sale doesn't close or doesn't close on time? How much time do the buyers have to vacate? And what happens if they don't vacate? Number two, should the sellers be paid a non-refundable deposit from the buyer and down payment prior to possession to protect them? Number three, should the buyer's lawyer receive irrevocable instructions from the buyer that completion will occur as soon as the mortgage proceeds are available? Four, how much is rent or other remuneration will the buyers pay and when is it due? Should there be a security deposit? Five, is the buyer permitted to modify the home without the consent of the owner? And if the closing doesn't take place, does the buyer have to return the home to its former condition? Number six, who pays for the utilities? Do the utilities go in the buyer's name or not? Seven, who is responsible for the ongoing maintenance? Landscaping, pool, hot tub, all those things. Number eight, who is required to insure the property and the buyer's contents that will be placed in the home? What if it burns down prior to closing? Whose insurance company is up for the loss? Number nine, can the buyer sublet the home or a portion of it? Can he rent out the suite in the basement? Number 10, is the buyer going to release and hold the seller harmless from liability if something adverse happens to the buyer before closing? How does that work? And 11, are pets allowed? Now, although drafting a buyer early possession agreement is outside the expertise of a realtor, the seller's lawyer can definitely handle it. And as we've discussed, there may be times when buyer possession before closing can help both parties. And if so, and if the seller feels it's a good move, the seller should definitely proceed. Yet proceed with caution. Background check those buyers as thoroughly as possible and obtain the advice of your lawyer.